Hey everyone, welcome back to an all-new episode of Plan on It with attorney Christopher E. Botti, board certified specialist in estate planning, trust, and probate law. I am your host, Mike Leon. You know, Chris here, he's got more than 30 years of experience helping individuals and families plan for long-term care and protect what they've built. And in today's episode, we're going to be talking about a revocable living trust, what it is, and how proper funding ensures it'll actually work the way the families are expecting it to work. Chris, it's good to see you as always. Maybe for somebody out there that's watching this for the first time, they stumbled upon this. They've never heard the term, right, of revocable living trust. They're not sure what it entirely means. Can you kind of explain what a revocable living trust is in straightforward terms for us?
Yeah, I'd be happy to. Thank you for having me, Mike. Good to see you. Okay, so there is a lot of misinformation about what a trust is or what a revocable living trust, but it's basically pretty simple. Okay, so think about revocable means, we call it a revocable living trust. Revocable means you can change it or modify it or undo it at any point while you're alive. So it's not set in stone. So that's revocable. Living means you created it while you were alive, as opposed to something being created as a result of your death. Okay. So think of the revocable living trust as a legal entity, because it is under California law, that you create while you're alive. And that entity will then have assets transferred to it for the purposes of funding the trust. And when you pass on, that entity still exists. And so because that entity still exists, the next person who takes over the trust is called your successor trustee. They succeed you, and they can take over the trust and distribute the assets of the trust to your designated beneficiaries without any court supervision. So the reason why it avoids probate, which is a process in California that you want to avoid at all costs, it is agonizing, okay, is because it's an entity that basically continues to exist despite your demise. And through that entity, you can distribute your assets without any court involvement privately within the family. So it is far superior vehicle to transfer assets than any other way of doing things, because of the lack of having to be put in a situation where you're facing a probate process.
Well, Chris, you just mentioned the other vehicles, so you opened the door there, because I'm sure a lot of people listen to this and they're like, well, what's the difference between a will? I mean, I got a simple will. That's enough. So explain why a revocable living trust is the more effective planning tool.
Okay, so they both do the same thing. Okay, when I die, here's where my stuff goes. A trust will do that, and so does a will. The distinction is very simple. Under California law, wills must be probated. They will have to go through the probate process. They're not an entity that comes to life until you pass on. So trusts, however, they do not go through probate. It's that simple. So under California law, if you have a living trust that's properly funded, the courts don't get involved whatsoever. It's that simple. Wills go through probate, trusts do not. And it's the law. Nothing complicated. Right?
Nothing complicated. You explained it now.
they do the same thing. It's just one gets the courts involved. So why not do the one that doesn't get the courts involved? You save a ton of money if you avoid the probate process.
I've heard that from a lot of attorneys in your field about probate, how expensive it is, right? People want to save money. But let me ask you back on the trust part. So what kind of level of control does someone keep over their assets after they've placed them in this living trust that we've talked about?
That is a great question, because a lot of the fear, when you don't know, if you haven't taken a deep dive and understand truly what a trust is all about, is the fear that you will lose control of your assets once you establish a trust, that somehow you need to get permission from someone in order to use the funds in the trust. And that is, nothing can be further from the truth. When you create a trust, you are the creator of the trust, also known as a settler. I don't like the word creator because it sounds too biblical, but you're the person who created the trust, okay? So you wear three hats. You're the person who established the trust. You're the person in charge of the trust, called the trustee. So you control everything in that trust. What decisions that are made to buy, sell, open or close, use assets are entirely yours. You're answering to nobody. You've got full control, okay, while you're alive. And so there's no loss of control whatsoever with the revocable living trust. It's basically as if you still are the owner of the assets as far as California law is concerned, as far as the IRS is concerned. You still control the assets like you did before you established the trust. But the only difference is you're wearing a different hat. You now have the hat of trustee versus just an individual holding title to assets. It's, again, not complicated,
Right.
very powerful, but essentially it's that simple.
Right. Chris, then what kind of assets are typically included in revocable living trust? Which ones usually stay outside of it?
Okay, so the ones that should go in, of course, real estate. So if you own a home, you want to transfer your home to your trust. If you have rental properties, you want to transfer your home to a trust. And that is true of assets that within the state of California. You want to transfer your California properties into your California trust, but also for assets, real estate that you may own outside of California in other states. All that should be transferred to your revocable living trust. Bank accounts is another example of assets that should be transferred. Brokerage accounts, stuff like that. Personal property should be transferred to your trust. And that's done with one document. It's very simple. But there are certain assets you own that you can't be put into the trust because they are technically trusts themselves. And the largest class of assets that can't be transferred to the trust are your retirement assets, whether it's a pension, a 401k, an IRA. You have to designate beneficiaries on those. So you're not going to transfer ownership of your IRA to your trust because that would trigger a massive taxable event. It would no longer be an IRA and you'd be paying taxes and potentially penalties on that. So there's a world of assets that exist outside the trust. They're technically their own mini estate plans, and those don't get transferred to the trust. Okay. So basically some stuff goes in, the bulk of what you own goes in, but there are certain very significant exceptions where they have to be transferred to your beneficiaries that you designate, and they can't be transferred through the trust. You have to actually have them outside the trust.
Let me ask you something on the real estate front, because obviously that's the biggest asset, as you mentioned. So you transfer a home, maybe a rental property, into this. I would love for you to explain a little bit more how it works, but also what if the lender objects? What would you say to someone that's worried about the lender potentially objecting to that property being put in the trust?
Well, if the lender objects, you basically tell them pound sand, because federal law, that's true. Federal law prevents lenders from doing anything about a transfer to a revocable living trust, particularly with primary residences. So there's protection in federal law that as long as you're controlling the asset, you're the beneficial owner of the asset, which in the revocable living trust you are, because the trust is established for your benefit first and foremost. There's no consequence in transferring an asset that's a piece of real estate with a mortgage on it to a trust, okay? In fact, you don't even have to tell the lender. They can't stop you from doing it. Now, that is a common misunderstanding too. It's like there is protections under federal law that prevent lenders from making your life miserable by just simply transferring your home to a revocable living trust, okay? So that can be done without any restrictions whatsoever because of the federal law protections.
Chris, I've heard you say this funding the trust properly a couple times, this phrase. Can you kind of explain that phrase a little bit more, like what that means, but also like what tends to happen if it's not funded properly? Well, like what challenges does that create for a family down the road?
Yeah, so let's first talk about funding the trust, because a trust essentially is a stack of paper, right? It's a legal document. We, as attorneys, we work our magic with paper. That's what we do, okay? Especially estate planning attorneys like myself. It's paper, right? Paper means a lot in this country, okay? And so having a trust, a stack of paper about maybe a half an inch thick, okay, if done correctly, is just a stack of paper. That's essentially worthless, right? It's not going to do anything. Yeah, great, I have a trust, but if there's no assets in it, it is essentially worthless because it's not going to do anything. So you must fund your trust in order for it to work its magic. And so the process of funding the trust when it comes to real estate is a deed. So there is a deed that was recorded the day you closed escrow on your home, okay, that proves that you own your property. And what happens is an estate planning attorney will take that deed and create a new one, transferring it from your name to you as trustee of your trust, and record that deed with the county recorder, okay? And that deed will get recorded, and then it's titled in the name of the trust. And once it's titled in the name of the trust, it avoids probate. So that's the protocol for real estate. And with bank accounts, the protocol is different. You will make an appointment at your bank, sit down with someone, and ask them to retitle the bank account in the name of the trust, okay? Now, failing to do that, if you make a mistake and you do a living trust, you put your home in your living trust, okay? And it's all set up correctly at the very beginning. And then later on, as time goes on, you say, well, I want to buy another property, for example, or I want to open up a new bank account. And you fail to put that property into your trust. You could have a probate because of that. That mistake could lead to a probate. And so you want to be careful. And so you should do a self-assessment. when you get the trust initially funded, if you have an attorney, you really should use an attorney to do this, because mistakes cost way more to fix than doing it correctly with proper legal advice. But the attorney should help you with the initial funding process. And then once that's done, you have the peace of mind knowing that it's going to work smoothly if something happens to you. But later on, as time goes on, because you're going to continue to buy, sell, open, and close, transfer assets, and you're going to live your life the way you normally do without restriction, because the trust is never going to get in the way of you doing that. But if you buy a piece of property and you fail to put it in your trust, you could have a probate, which would be an unfortunate event. We don't want the courts involved. That's the whole reason why we're doing this. So we want to avoid mistakes. And the way you avoid mistakes is every so often, maybe once a year at a minimum, just take a look at your assets, do an inventory of what you own, and make sure it's either in the trust or there's beneficiaries on the accounts, for example, in the case of IRAs and pensions. Do that self-assessment. If you do that, you're avoiding problems down the road, because when you have a problem down the road, the only recourse is the probate courts. The law of trust is baked into the probate code. Probate courts deal with any trust issues that are when there are mistakes in funding. So the goal is to not get the lawyers involved and having to get the courts involved because you make mistakes. And it's really easy to make a mistake, but it's also really easy to fix it.
Also really easy to fix it. Chris, I can't thank you enough for the time, the insights, breaking this all down for us. I appreciate it as always.
I appreciate you. Thank you very much, Mike.
And thank you to everyone out there for listening again to this installment of Plan on It with attorney Chris Botti. To access more resources, including the 2026 Medi-Cal ebook and upcoming estate planning workshops, do me a favor right now, visit boddylaw.com. Thank you again for listening. But before you go, do me a favor, hit like, hit subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I'm Mike Leon. We will see everybody next time.